Hi everyone, welcome back to First Principles. Today we've got Gaurav with us. Gaurav is an Indian lawyer and he's going to be talking about intellectual property. Hi Gaurav.
Hi, Sagar.
All right, so tell us about yourself, Gaurav, a little bit.
I'm a lawyer. I'm an IP practitioner in India, and I breathe, sleep, and I eat IP all day long. So that's exactly what I do.
Perfect.
On the intellectual property side, I am looking into the enforcement, the prosecution, litigation. Essentially, I go to courts, I
Hmm.
file cases against perpetrators of law, of IP law, and then sue them, and then make sure that they go behind the bars for the infringements that they have triggered or of which they are a part of. And we track the complete supply chain on the counterfeiting and support on the investigation side. And
Hmm.
that's the role and responsibility and that I have been undertaking and following for almost over a decade now.
Okay, perfect. So you are just the right guy. Okay, so before I actually start today's topic about what exactly is intellectual property, I want to start with some what I think are more sort of fundamental questions, right? They might not be, but that's what I think. And you let me know if it makes sense or not. So, how would you distinguish crime versus tort?
Tort is considered as a civil wrong,
Hmm.
something that's morally wrong, but something that's um, perhaps not legally wrong.
Hmm.
The moment we cross that fine line of distinction between legal wrong and moral wrong is when we enter the criminal space.
Hmm.
From the IP perspective, I'd like to share an example with you. I think that's what will be what will make it easy for us to understand. So,
Yeah.
in IP, you see plagiarism is considered as a tortious wrong or as a moral wrong. Infringement, on the other hand,
Hmm.
is a civil wrong for which you can file a lawsuit, you can file an infringement claim, and you can successfully prosecute. So that is where crime happens. When I'm infringing someone's copyright, when I'm making pirated CDs, when I'm making pirated softwares, and downloading pirated content. But if I'm simply plagiarizing, so it's an offense which a university can take cognizance of and perhaps expel me or deduct my marks.
Hmm.
So that is where the moral wrong and the legal wrong, I would say, dichotomy comes into place.
Hmm. Okay, so I guess the way I would put it, and let me know if you what you think of this perspective, is that in a situation when it comes to like a private wrong or a moral wrong, but not exactly a crime, it's essentially two private parties, and then there is a conflict which is happening with them. State intervenes, and then essentially there is some that's what like a civil suit is. So if there is a compensation to be paid, the state makes sure that that kind of delivery of justice happens. In a situation of a crime, the state kind of assumes that wrong that was committed on the state, and it fights on behalf of the victims. And the whole idea is that the perpetrator's sort of liberty has to be curtailed, of course, after we figure out if the perpetrator is real or not. Okay, so is this accurate from like a layman? Like I don't know, I don't want to go and take a test and like pass or fail, but like is this okayish understanding when it comes to a metaphor?
I mean, it's quite close, but yeah,
Okay,
there are technical differences to which I may not be able to agree because
okay.
let's say you and me. So if there
Hmm.
is a violation that happens, if I slap you,
Right. Hmm.
that's a crime. That's a tort,
Hmm.
but that's still a crime. That's a punishable offense. If I stab you, it becomes a state case.
Right.
But if I simply abuse you,
Right.
it's between two individuals. It's very
Right.
private.
Right.
Perhaps that may simply be a tort,
Right.
which
Right.
could be a wrong. But you feel that I've intruded your personal rights, your private rights.
Right.
So
Right.
it really depends on the context of how the penal code defines a particular offense.
Okay. Okay. Got
I'm
it.
sorry, I'm a
All
little
right.
bit technical, so
No, no, that's fine. That's fine. That's fine. And I'm gonna keep going back to the basics. So it's gonna be a nice tussle in order to get something out. All right.
lovely.
Okay. The next question is again we'll come into intellectual property. We're climbing that hill. What is the definition of property as per the legal context in which you are familiar? So you've studied in India and the UK, right?
That's right.
So as per that definition.
So property, to put it very simply, is something on which you have a right to own, something which you can possess is a property. Now, property could be tangible, property could be intangible, could be movable, it could be immovable.
Hmm.
So that's a broad spectrum of property.
Okay.
And the
Okay.
moment we are talking about the intangible part of it,
Hmm.
that is where we are referring to the intellectual property.
That is where we are referring to the intellectual property. Okay. Okay.
The moment it is
Okay.
tangible, so something you can touch, you can feel, it could be like a remote, it could be a mobile phone. So all these are tangible products. These are all properties which you can own, which you can possess, which you can transfer, which you can let on hire.
Right.
So all of these are properties, and likewise you have immovable properties where you have plants, machines, homes. So all those also classify as property as per
Okay,
law.
so if one is trying to define it, is it correct to say that there is an entity, tangible or intangible, there is a wide spectrum, whatever, that is defined as property, and then you can do various things with it. So like there are certain restrictions that, like, I might have a home, but I might not be able to cut a particular tree on that particular property because that is a promise I made. So essentially property would be considered a relationship between that entity and the owner, and that relationship is being broadcasted to the wider community just to let them know that this is his, so don't infringe. And if you infringe, then the state is going to come with its big guns, and it's going to defend it because it defends property. Is that more accurate than the previous
That's
answer?
another way of putting at it. Yeah, it's a
Okay.
very well. Yeah.
Okay. Okay, got it. Got it. All right. So then again, the next logical question when it comes to this particular episode, what is intellectual property?
So I'll just take the cue from where you started on
Hmm.
property and intellectual property. Every intellectual property is a property which is derived out of your intellect. So there are
Okay.
properties which are not derived out of your intellect, and there are then properties which are derived out of intellect. Now, the ones which are not derived, let us first see them. As I mentioned, a house, a car. You own a house. When you create something into it, you're using your intellect. You own a car, but you've not put in any of your intellect in making that car. The people who've put in their intellect in making that car are the ones who own the IP in that car, intellectual property in that car.
Hmm.
So, to put it simply, every intellectual property has to be property in the first place. And you could treat your intellectual property the same way you treat your property. For instance, what is it that you can do with your property? You can own it and use it for your own self. You can sell it to some third party. You can give it on rent, or you could mortgage it. So broadly, you could do these four things with your property.
Yeah.
Likewise, with your intellectual property, for instance, it's your trademarks or it's your patent, you could do exactly the same stuff. You could
Hmm.
own it and use your trademark for your own goods and services.
Hmm.
You could sell it to someone. For example, you have your trademark valued at a particular number. WhatsApp was acquired by Meta.
Yeah.
WhatsApp is a brand.
Hmm.
It had a goodwill. There was a valuation attached to it, and Facebook acquired it.
Hmm.
So it was sold. So the IP was sold just like any car or any physical property would be sold.
Yeah.
Or you could license it.
Hmm.
License means you could give it to someone on rent, put it simply. So you can license, you can allow someone else to use it. They
Hmm.
pay you royalty, which is a rent for using it.
Yeah.
The fourth thing is a mortgage. Once you have an IP which has a particular valuation, you could mortgage it, or you could pledge it, and receive some amount as loans.
Okay.
So that is how property and intellectual property are related, and
Okay.
that's what's there in common. So every IP has to be a P in the first place.
Yeah.
The biggest difference being that it's intangible. You
Hmm.
can't touch it, you can't feel it, you can't see it, but it exists.
Okay. Okay. So what is the I understand owning. I mean, okay, I want yes, if you get very spiritual, nobody really owns anything. You don't exist, maybe your whole body doesn't exist. I'm not talking about that. Just talking about common sense axioms based on which sort of like I guess common law derives. And even if we codify it, it's based on common sense. So from that perspective, owning something, it would make sense because that physical tangible structure is there. Owning a patch of land will make sense maybe, but like how do you own an idea once it's out? Like it's like, for example, if I send you a PDF, um my PDF still remains with me. I'm sending you a copy. So that idea, it's not scarce. I uttered it. I still have it in my mind. The moment I uttered it, somebody liked it, it got replicated. So what's the whole idea of, which is some, sorry, what what's the whole plan of taking something which is apparently out there, open, making it scarce, and then making it into property? What's the whole point? Why do that?
So let us understand the genesis of IP then, because
Okay.
we are trying to touch upon why is IP granted in the first place to someone?
Yeah.
Why is an
Yeah.
IP right given to someone?
Yeah.
So the concept of IP came into existence because there was a need to recognize, to give some recognition, and to incentivize, to give an award to someone who has put in their hard work to create something.
Okay.
So when you write a piece of paper, when you write a piece of paper, penning down your thoughts,
Right.
someone else takes that piece of paper away from you.
Hmm.
Would you feel that you've been there's a crime of theft committed against you?
Yeah. Yeah.
Because
At least cheating. Yeah.
so someone stole away your stuff. You wrote a piece of paper, you penned
Hmm.
down your thoughts,
Hmm.
invested a couple of hours, and someone just took it away.
Hmm.
So you put a lot of effort in creating something. Now let's talk
Hmm.
about the technological advancements that we have today. So that will give you a better perspective.
Hmm.
There are different types of inventions, innovations, creativities which are recognized under the IP law. So there is not one single subject called as IP which can cover everything. So
Okay.
IP has been devised into different forms of laws, different areas. For example, there could be copyright, if it's a literary work, if it is an artistic work, if it is a
Hmm.
dramatic work, cinematographic work,
Hmm.
or if it's a musical work, all of that is classified as a copyright.
Okay.
If you create something and if you invent, if there's an invention into consideration, that is when patents come into play.
Okay.
But if you've created a brand of your own, then you invest into that brand.
Hmm.
So when you start off with a brand, nobody knows you. You invest, you advertise, you attain a certain sales, you have celebrity endorsements, and then you become popular, and then
Yeah.
people start to copy you.
Yeah. Yeah.
Likewise, you have designs and other areas of IP laws as well. So it is your creation, your invention,
Hmm.
your novelties which are being protected by the IP, and it's all your hard work.
Right.
If it is not rewarded, then the society will not progress. So why is it important to give that kind of a right in that IP? I'll give you an example.
Hmm.
I remember as a child when I used to dial a phone. I used the dialer tone. I used to pick up the phone and I used
Hmm.
to take that round numbers and I used to call the dial tone.
Yeah.
And it used to take me at least, I would say, 60 to 80 seconds to dial a complete number to reach out
Yeah.
to someone. And then came the cordless phone, which was a
Hmm.
revolution.
Yeah.
After cordless phone, you could simply send your message to someone through a pager.
Hmm.
From pager, we started with the journey of mobile phones. And the mobile phones was a simple talk and receive phones where you could either text messages or you could receive calls. Then gradually there were more features introduced.
Yeah.
And today we are in the era of smartphones.
Right.
All of this has been possible because there is a set of individuals, there are certain people who are investing their time, effort, and resources in creating a new technology which can benefit the mankind.
Mm. Mm.
Unless their efforts are recognized and rewarded,
Mm.
there will be no advancement. There will be no advancement of technology. Why will someone put in their hard work and create something unless they are committed? Okay, if you do this, you will be given an exclusive monopoly
Mm.
to commercialize your product for a certain period of time.
Mm. Okay. Okay.
It is
So
only for a certain period of time.
yeah,
It is not
I
for
was about to
every.
come. I was about to come to that. I guess the obvious question is why. I mean, they invented it. Why don't they keep the proceeds forever?
That's a good question as well. So when I'm creating something,
Hmm.
The law says, and there's a reason for that. The law says that there's only a certain time to which you can commercialize, monopolize, and claim exclusivity in a particular invention or a model.
Hmm.
Why? Because after a certain time, your invention must be available for the benefit of everyone. You've gained a certain monopoly for a certain period of time, and
Hmm.
you've extracted enough revenue out of it
Hmm.
which satisfies and which compensates the hard work that you've put in
Hmm.
creating it.
Okay.
So you had enough time and you've commercialized it, but now
Hmm.
everybody should be able to use it.
Hmm.
So there's a time limit. Why? Because it is okay, you've created something, you did something for the humanity, it's good. But now it's time for the entire humanity
Hmm.
to to enjoy that,
Hmm.
enjoy the hard work of your labor.
Hmm. Hmm.
During the COVID,
Hmm.
there were certain vaccines which were created. And there were certain companies, some pharma companies, who applied for patenting those particular vaccines so that it was their creation. They were the ones who could find the cure to coronavirus.
Hmm.
Now, the world was at such a stage that it was not the right time for those companies to claim monopoly and then say, okay, now all the all the medicines will be manufactured and distributed through their authorized channels.
Yeah.
Nobody else could do it. So a
Hmm.
lot of companies gave up their patents
Hmm. Hmm.
for humanity, for mankind. And
Okay.
in India also, the Indian government had an outreach. I will not take any names, but yeah, there were Indian companies who gave up their patents and they did not claim them. They did not contest towards others who were copying their chemical compositions and formulas.
Hmm.
But that's only for your patents. So, for example, patents standard timeline is 20 years.
Right.
After 20 years, anybody could use it. For designs, it's 15 years.
So just very quickly, so what are the types? So patents, designs, trademarks, copyright, what else? And what are they?
You have So then you have the geographical indications as well, which
Okay.
in many countries is known by the name of appellation of origin.
Okay.
Scotch whiskey,
Yeah.
Swiss chocolate,
Hmm.
champagne. These are all
Champagne.
examples of
Yeah.
appellation of origin or geographical indications. Basmati rice
Tequila as well, I suppose.
as well,
Hmm.
tequila.
Cuban
Then you
cigars.
have Assam tea, Darjeeling tea,
Yeah.
for obvious reasons. So yeah, these are all examples of geographical indications. So when it comes to designs, you have 15 years. Designs is something, a right that you have on the shape of the product.
Hmm.
That has the least amount of time because the designs they go out of technology and they go out of fashion very fast.
Okay.
So and after a while, the kind of generation we have and the kind of dynamic times that we are living in, people want to see something new, something that's more aesthetic, something that's more appealing to the eye
Hmm.
every now and then. Something that has more ornamental or aesthetic value to it. So
Yeah.
Design rights are very limited for 15 years in many countries, including in India. Patents have a standard of 20 years.
Yeah.
For your GIs and trademarks, for geographical indication and trademarks. So these rights are there for almost like perpetuity. Why is that? Because a brand that you've created,
Yeah.
Ford, for example, Ford as a brand for cars, it was created in 19th century. It's almost a 140, 150-year-old brand. And so it continues to make those cars. It continues to invest in better technology.
Right.
So it's not that someone else can today come in the space of automobiles and then start off their business under the brand Ford, or they can start selling automobile components under that brand.
Yeah.
Because it's an investment that they've made. So all they have to do is they have to take care of their trademark renewals on a timely basis. Regardless, their brand it survives, it subsists as long as they use the mark.
Okay.
And same is the case with geographical indication. Something that originates from a particular place continues to enjoy those rights, and those rights are meant to benefit indigenous communities and the particular sector of people who hail from that area. So that's for your trademarks and geographical indications. For copyrights, it's interesting that the rights are there till the lifetime of the author. So
okay.
So long as I'm alive, the copyright subsists and I enjoy. For example, I have written a movie,
Right.
I've written a novel, so the rights in that work, it will continue to remain in my name, and I continue to enjoy those rights in my lifetime and 60 years thereafter.
Right. And 60 years thereafter. Okay.
So
okay.
Even if I'm not there, my legal heirs continue to enjoy the rights. Or if I've sold those rights to some third party, for example, if I've written a book and I've sold it to a publishing house, so the publishing house will enjoy those rights for the next 60 years. Or if I've created a movie and I've given it the sound recording rights or the cinematographic rights to a particular production house,
Right.
so that production house will enjoy the rights for another 60 years.
Okay. I want to talk about a concept that I have in mind, which I'm sure is already out there, but I haven't researched it yet, right? So it's the gradient of ownership, right? The gradient of ownership. So on the one hand, we've got I think it even has a name. I think it's called alloidal title, which means that absolutely no interference, totally sovereign territory where the person itself is sovereign. The trade off, of course, is that they need to defend the territory themselves. That's the whole kind of initial reason for a state, collective defense agency or whatever. So good luck when people with big guns just come and you can defend them with your hands and perhaps here in the States with your guns, but yeah. So that's one. Then we've got the fee simple freehold property title, where that is what most people mean when they say I've got like full ownership. In this situation, you can basically alienate yourself from your property. You can give it away. There might be some local laws here and there, but basically in common law systems, in this scenario, you can do whatever with your property. There are other sort of tiny non-fee simple sort of systems where you can only give it to a particular air or a particular line. But yeah, then you've got the leasehold where you can use it for either your life or for a set amount, but then it's taken back. Then you've got the short-term, like sort of rental leasehold kind of like lease for the year, sorry, rent for every month, that kind of scenario. Then you've got the hotel kind of scenario where you're just there for like a very short-term kind of a place. And then similar situations when it comes to, I'll give you an example, when it comes to a car. So traditionally, when we bought a car, right? And then we went ahead and started whatever changes we made thereafter, it was ours, right? Where it gets tricky is, have you heard of the right to repair argument? The right to repair. Okay, that's where it gets tricky. So all of this, explanation I gave about the whatever this particular scale of
Gradient
ownership.
of ownership.
Yeah, gradient of ownership. Now, where does right to repair come in? If I buy an iPhone, is it mine, or have I only leased it from them? Have I only licensed it from them? They can just take it away anytime. Is everything a subscription, or do I actually own things in the intellectual property world?
Um, these are two different concepts actually,
Okay.
and
Okay.
IP has a little role to play because IP is not something that is, of course, it does not exist in isolation, but IP does not get transferred when a consumer buys a product.
Okay. Interesting. All right. Mhm.
So the IP rights stay with the company.
Okay.
So for instance, today I own an iPhone,
Hmm.
and as someone else carrying a fake iPhone. And let's make it simpler. I'm wearing a genuine Louis Vuitton handbag, and I
Okay.
know someone around the corner is carrying a fake one.
Hmm.
I feel aggrieved. I feel
Okay.
like I because when I'm carrying a LV handbag, I have a superiority,
Okay.
and when I see someone else who I feel is not worthy is also carrying a bag, and I see them that's a counterfeit. That's a definite counterfeit. I
Hmm.
feel aggrieved. So do I have a right to take any legal action against such entity who's carrying a fake Louis Vuitton bag?
I mean, do you
I
have,
feel bad.
you feel bad?
I feel
Okay.
bad.
All right. Let's think about it. In a mature liberal society where individuals, as long as there is no actual harm caused, the state doesn't intervene just because you feel bad. So I'm assuming I'm going with no. You don't, you don't have a right to petition
Exactly.
against. Okay. All right.
I have no
Okay.
right against such person who's carrying
Mm, mm,
a fake Louis Vuitton bag.
yeah.
But who has a right?
The Louis Vuitton, who the ones who, yeah.
Exactly. So when I'm
Yeah.
transferring my when someone is buying my product,
Mm,
I'm not transferring my IP with them.
mm,
Now, if you draw a similar analogy on the repair or on the subscription or on
yeah.
any other point, so
Right.
these things they don't exist in absolute. So these are not absolute rights when you have the
Right.
product.
Right.
The companies, so it's a business model. If you ask me, it's a business
Yeah.
model where the companies want to make sure that you are dependent,
Yeah.
you remain dependent on them, and
Yeah.
the relationship is not over just because you bought a product. I get
Right.
my sales. I want you to come back to me.
Okay.
How do I make sure that a person who's come to me once comes to me
Yeah.
again?
Yeah. Yeah.
So it's purely a business model, and there is no sense of ownership. I have a phone, the contents of which are perhaps readable elsewhere.
Right.
Which I may not even have an idea.
Yeah.
There are so many different apps which are pre-installed. I, as a consumer, as a layman, perhaps don't even know what are the implications of most of those applications.
Right.
The pre-settings of the phone may contain a feature wherein my microphone is on or my video is on
Right.
and my voice is being recorded or my text message is perhaps readable elsewhere. Today we are living in a different world.
Yeah. Yeah. Yeah.
Like so the sense of ownership, I would say it's a false sense of security that I own something. I really don't. I've paid a price to use a product.
So like a subscription, which this makes me sad here because it's almost like I want to fight back because it's like, okay, fine. I understand that our current products, okay, let's say you got an air conditioner 20 years ago, or in India we have water coolers, right? These coolers, not the ones you drink from, but those coolers. You bought it, right? There was no constant firmware updates happening. You didn't have to really form like okay, you could have formed some kind of a spiritual relationship with that entity, but you did not have to keep basically monitoring a relationship between that entity and the producer of that entity. It's almost like constantly. I don't know. The analogy is that this is like an old relationship which you need to keep monitoring. I mean, if it's sorry, let me just try and collect my thoughts again. It's almost like after a divorce, a situation where somebody is fighting about a child. Like like if I bought something, my thing is it's mine. Now we need, maybe the law needs to evolve and to this particular new situation where in the past, if I buy like a chair, it's mine. There is no constant updates happening. But that's the case with particular mobile phones. So perhaps uh, consumers need to be guaranteed the right to repair when it comes to replication or use of that particular intellectual property in order to repair. That's it. Not to replicate it, not to profit off it, just to repair it. Is that a reasonable idea? Or is that also no? Like everything has to be a subscription?
I never said I support subscription. I only
Okay.
shared the model with you and how things work. We need
Yeah.
to understand how we humans have evolved as a society.
Okay.
We've moved from a need-based society where we were dependent on each other. We were
Mm,
creating products only to fulfill our needs for survival.
right.
The air cooler or the basic cooler system earlier that you
Mm,
referred to, it's a good example. That was the need of the hour.
mm,
That was a matter of survival. If you won't switch it on, you will perhaps die out of heat stroke.
yeah.
So the idea was to create something so that the people could survive.
Yeah.
Today, the needs are artificial.
Mm,
That you really don't need an iPhone to survive.
right. Right.
You really don't need certain products to survive. These needs are created. So, and to create these needs, now the business models, that the dynamics of a society have changed to the extent that they want to make sure that the needs should not die.
Mm,
Because
mm-hmm.
if a need to own an iPhone is dead, how do I
Yeah.
create
What'll I eat?
a revenue model that's more sustainable? I need to
Yeah.
create another need. I
Yeah.
need to create something that that is more desirable.
Yeah. Yeah.
So we live in a different world today.
I know.
Literally no
Very,
comparisons to.
very tangentially, maybe that is the way companies should think about it. Maybe instead of getting really good at something and then expecting that forever you'll keep trading in that particular one thing is an unreasonable expectation. I think the conglomerate model is better because, hey, trends change, industries change, they get created, they get destroyed. So if you think, what you said, that we'll have to cater to more needs and create more needs. There are always more needs never gonna, well, okay, fine, there are always more wants and you can keep catering to wants, right? So if, let's say, a mobile phone is already fine, let it be fine for like 10 years. Maybe you don't need to produce so many units. Maybe start working on something else that a person wants instead of just keep shipping mobile phones, right? But anyway, that was an aside. But like, it's just like, I just get a little, okay. Let's talk about abuses of intellectual property. Does that happen? And what are some common instances?
That's a tricky one for me because I'm someone who is a hardliner when it comes to. I'm a pro IP guy. I've always
Pro
been.
IP guy.
Yeah,
Okay.
I've always vouched for IP because that's my bread and butter. Honestly, like I go to
Okay.
courts and I explain to the judges as to
Right.
why IP is important.
Mm,
And I have met many academicians, many scholars, many law enforcement authorities who don't see IP infringement as a crime
mm, yeah.
because they feel that if someone who's getting a Rolex watch for 500 Indian rupees
Mm,
and it makes him happy to wear that, or a 2000 rupees watch for Rado,
yeah.
so the seller knows he's selling a
Mm,
counterfeit product. The buyer knows he's buying a counterfeit product. And but they're both happy, they're doing business, and there's no element of cheating, there's no public deception, there's no confusion in the
yeah.
market.
Yeah.
So why do you want to enforce against such people? But
Yeah.
then
Yeah.
there's another school of thought which I realized when I got more into the law enforcement part of IP, as to how IP is an organized crime, how there are IP syndicates which are
Huh.
operating. So there are studies prove that the 2016 Paris terrorist attacks in 2016 were funded by sale of fake Nike and Adidas footwear. Now, it is a seemingly harmless crime. Like if someone is selling a fake footwear, like who is going to harm? Like it is only the multinational corporations whose interests are being affected.
Yeah.
But when you see the entire chain of counterfeiting, they don't pay taxes in the counterfeiting industry. It's a parallel economy, which is worth billions of dollars. There are studies by OECD, by ASPA, by Facet. There are various organizations globally who do a lot of study on the counterfeiting trade. So
Yeah.
there are various studies which have proven that how this parallel black market
Yeah.
is harming the interest of consumers. Because just see the market in which this 2000 rupee watch is operating.
Yeah.
If these goods were not there, people would still come to buy watches in the same market. They're buying those Rado, Rolex, Omega, Tissot, etc. only because they see them in open. What
Okay.
if those watches were not there? Perhaps a startup Indian company or startup company elsewhere would be coming up with its own cheaper brand, but and then get certain degree of traction, a certain degree of sales. So these counterfeits are fighting against the economy, against the micro, small, and medium enterprises, businesses. They don't pay taxes. They deploy child labor. You see the level of violations on the legal side and on the civil side which are happening. This
Right.
entire industry, it's massive. It's
Okay.
massive. This I've only shared one example of 2016 Paris attacks. There are other studies which prove that there are factories in China which are funded by terrorist money, by terror financing. Now,
Right.
now, your question next should be like, why is it that the terrorists are going to invest in the counterfeiting industry? Like, they could invest in other illicit trade. They could invest in gold smuggling and drugs. There are so many other. There are arms and ammunitions. Of course, they are there, but they are more
Right.
risky.
Right.
If I invest in a counterfeit factory, a manufacturing
Right.
unit in China or elsewhere, where I know that my return on investment is very good. Why is it that my ROI is good? Because those factories, they don't declare what they are selling.
Right.
There are mostly cash transactions. There are mostly uh, everything is unaccounted,
Hmm.
and they use big brands to sell their products. They trade upon the goodwill and reputation of well-known brands, and then they operate in a different world. So it's hard to
Hmm.
catch them. And I could give you examples of cosmetics. For example, there are a lot of popular brands of kajal. So we did some raids against counterfeit kajal of various globally renowned brands. The market price which was about $4,
Hmm.
about 300 rupees, 350 rupees. That's the market price of those products. The
Hmm.
cost of that product for counterfeiters
Hmm.
was merely 2 rupees.
Hmm. Hmm.
They were using a sketch pen
Hmm.
and selling it as kajal, and people who were using were harming their eyes. Now, let me put a question to you.
Hmm.
Would you knowingly buy a counterfeit Nike t-shirt or maybe a Michael Kors wallet or a Prada belt or a Bulgari sunglasses or a fashion brand product, knowing it's a counterfeit, but you'll still
Okay.
you're getting it
So
for dirt cheap price
I
and very good quality. It looks exactly the same. You're like, okay, that's a good deal. You buy it.
I will just give you different phases of my life, right? So in this particular phase, what I would do is if I can't afford the actual brand I want, I'm gonna go with a brand which gives me a similar quality, but it's not pretending to be the brand I want, right? Some years ago, yes, I would have wanted it because of the prestige that it got me. If I did not have the money. And that's what I'm really, really struggling over here because it's like okay, we'll get to the mafia angle in one moment, but it's just somebody's okay. Reebok made a shoe, and these guys call it Bebop or whatever, and they have a similar shoe with a slightly bad quality. It's even called Bebop, right? They're not claiming it's Reebok, but there is inspiration. Like how far is too far? Otherwise, you will not have any inspiration. What's the line? That's what I'm trying to get at.
There is a fine line between inspiration and imitation.
Okay.
IP is against imitation. IP is not against inspiration. If you are inspired by Reebok, then follow its company has the values, the core principles and values of Reebok. if you want to follow a particular brand, see how they became a brand, and create something of your own. I think if each one of us, if we invest certain bit of time
Hmm.
in investing in creating something, the reason why you're using Reebok is because you know that Reebok is a popular brand. People have a brand recall. Well, there's a mass recognition. And if I make my brand as Reebok, there will be a consumer confusion. Some consumers, some unsuspecting consumers will end up buying
Hmm.
Reebok, assuming it to be Reebok. And maybe, oh, later on they'll find, oh, if not end up buying, at least there is something called as the initial interest confusion, the theory of
Yeah.
initial interest consumer. So you are drawn to a particular product is because you saw that stripe logo, which is similar to that of Reebok.
Hmm.
So ultimately, Reebok was trying to trade upon the goodwill and reputation of Reebok. These kind of things are not permissible under law, and there are several reasons. So I gave you the hardline reason on anti-counterfeiting and anti-piracy on explaining how this mafia is linked and how it is the entire trade which is affected because of, and the exchequer money is lost. Of course, the company's brand reputation is also at stake, and
Hmm.
they have their proper brand protection teams who are, the companies invest a lot in ensuring that these counterfeits are not there in the market. So it's
Yeah.
not that the companies have various security features on their products.
Hmm.
They are investing a lot to ensure that they stay clean of the market, but somehow the it's a cat and mouse race between the IP
Yeah.
holders and the criminals. You in fact just mentioned that 10 years back, perhaps you would have been lured into buying a replica, and as on date, you will not do it. But let us say 10 years back, let's go down 10 years back, because I, I still am targeting the youth, which
Hmm.
which is a massive number globally, which
Yeah.
will end up buying a replica bag or a replica sunglasses, watches, footwear, etc. of a popular brand. But would you knowingly buy a counterfeit alcohol, or a
Hmm.
counterfeit pharmaceutical product, or a
No.
counterfeit face wash?
Hmm. No.
So now that's being hypocrite. Now,
Hmm.
if it's a counterfeit product which
Hmm.
will not harm you, or perhaps seemingly not as
Hmm.
harmful to you because
Huh.
it is not related to your direct human contact and consumption, you will buy
Yeah.
it. But
Yeah.
when you know it is harming your human contact and consumption and it might affect you, you want to have the best product and you are willing to pay the price for that.
Yeah.
That's the same IP law which protects a pharmaceutical product, or the baby food product, or a diaper, or a female hygiene product, versus any luxury handbag or any other product.
Okay.
The
Okay.
law is
Okay.
the same for all the
Hmm.
products. It is,
Hmm.
but we as consumers, we make our choices. I'll tell
Right.
you my experience.
Hmm.
When I was when we were in the UK together, I remember. So remember there was World Cup in 2011 at the same
Hmm.
time.
Yeah.
I in my room, I watched India versus Australia. I was in my home in Leodes in the university accommodation. I logged on to my laptop, and I Googled search live streaming India versus Australia, and I was directed to a link which
Hmm.
was not authorized because the broadcasting rights, the IP rights, were with Sony and ESPN Star Sports. I
Okay.
was directed to a parallel link where I could live stream and enjoy the match. So
Hmm.
I clicked on that link. I watched that match. After half an hour, that link became disabled. I Google searched again. I was directed to some other links.
Hmm.
I continued watching on those links. So perhaps I used about 3 or 4 links to watch the entire match.
Hmm.
And 1 week later,
Hmm.
I received a notice under my room that
Oh boy.
your IP address number so and so, your computer system number so and so was used for live streaming of India versus Australia on so and so date. Like that's how close they monitor. And this is an offense. That's an offense, and the fine was 750 GBP.
Oh boy.
So when I spoke to my fellows there, my colleagues and other people who were in the same accommodation, there were about three more of them. I spoke to Indians, my Indian friends over them, like, this is what I received. Like, they're like, हमारे को भी मिला ऐसा. Like, we also have a similar notice from the university, and we all gave an apology. I will not be doing it again. So that day, I learned a lot about IPs. I'll tell you one more instance that happened with me. I ended up making a very good friend from Britain, and we were just doing some shopping. Um, we were in a store, um, um, just window shopping in a mall. I can't remember exactly, but it was in Leeds itself. And he ended up buying CD, a music CD. I told him, like, she was spending £20 on this. It was 19.9. I still remember. £20 for this. I'm like, I'll just give you a link and download it. I'll give you a link. You just download it and have the exact same quality of sound on your system. He's like, no. If I download it from the internet, the creator of this piece of work will receive no royalties.
Yeah.
But if I purchase this, he will be benefited out of this. So they appreciate paying for the work. And that is when I saw the difference in the intellectual levels and how honest they were. So I was shaken by that. I was literally shaken. I'm like, no, wow, like that's inspirational. We don't do that back home here. Like we don't think it twice before downloading pirated content. Like this is the main difference. So today I'm doing a lot of training in the schools, colleges, lectures, just explaining them on the best practices of IP. The first thing you need to do is stop downloading pirated content. Start appreciating the IP of someone else. That is when you will create your own IP. That is when you will understand what is there. Like IP, William Shakespeare, he said, "What's in the name?" But he had his name under it, right? So, naam mein kya rakha hai? He has his own name under that statement because he wanted people to know that he was the one who said it.
Yeah.
That's so. I think as a best practice, we need to start appreciating the IP of others. And once I was back home here, I became a fan of IP. I joined an IP firm, and since then, it's been almost now 13 years. I've not bought any counterfeit product.
Yeah.
At least knowingly. I got a fake cosmetic product from Amazon when I bought and I ordered it online. That was an unfortunate instance, but Amazon was happy to process the refund, and they instructed me to throw away the product. No questions asked. Simply asked me to just throw away the product and dispose it off. Don't use it. It was a face cream, and I could simply tell it's a counterfeit product.
Okay.
Those are some of the experiences I thought I'll share with you, which will be relevant for everyone to connect with.
Yeah. Okay. I mean, I got some sense here that I think one of your example would have been taken care of by just ensuring that the admixture, like in India we call it the milawat, right? I mean, the content is what you are saying it is, right? That is a different question than brand and IP, right? That's a different question. But I mostly agree with you. So I guess if I can maybe reword whatever you said, is like the whole reason for the existence of intellectual property as a concept is we need to award people who can tinker and basically create new wealth. New technology, if it's helpful, essentially creates new wealth in terms of numbers, but in terms of more goods and services and more desires being fulfilled, more goods and services being produced, more desires being fulfilled. That is a growing dynamic economy. And that embedded growth is what we all assume is why tomorrow will be better than today, right? Otherwise, if that embedded growth doesn't exist, tomorrow will not be better than today. Okay, so that's again because it's first principles. That's why I'm just trying to like or sweep up the layers. So that's the case. Now, there is a term called the Goldilocks zone, right? So if the Earth is just the right distance away from the sun. If it's any closer, death. If it's any far, death. Right? Maybe some of the life, but we won't survive. So intellectual property law is trying to create an environment of protection of the inventor or protection of the founder or whatever in such a scenario where they can monopolize that particular invention for some time so that they are incentivized to invest now and potentially lose their money, but not forever, because if it's forever then you're just engaging in rent-seeking behavior where new wealth is not getting created. All you're doing is just capturing access to the current wealth, and you just put up a toll gate, which yes is kind of illegal, and if you do it, it can cause a revolution. So that's why you are pro IP, but you're not like, but you don't believe that a creator should always, in perpetuity, forever, eternity, just keep getting the proceeds. That's, you don't believe in that.
Absolutely not. See, ultimately,
Okay.
the idea of creating IP is to benefit humanity.
Okay.
Ultimately, everyone should be able to reap the benefits.
Hmm.
Today, we see that, again, I shared one example of mobile phone. I'll share another example of storage devices. So
Hmm.
I remember in my school days, I used to submit my projects in a floppy disk,
Hmm.
and I used to struggle hard to copy and paste the content in the floppy disk.
Yeah.
It used to take hours. Then
Yeah.
from floppy disk, we came to the era of a compact disk,
Hmm.
where the storage was a lot more, the speed
Hmm.
was much better. Then we came to a DVD with a higher storage. From 700 MB, we went to 3.7 GB.
Hmm.
From a DVD, which was again a very vulnerable, a very fragile piece of storage device, we came to a pen drive.
Hmm.
From pen drive today, where do we store material today? Everything is on cloud. I mean,
Yeah.
everything is virtual.
Yeah.
So that is the level of advancement in technology just
Hmm.
happened.
Hmm.
I mean, that's only possible because the creator, the inventor, were
Hmm.
appropriately rewarded for their
Hmm.
inventions. Now, with the advancements in technology, with the changes and the overall dynamics which has happened over the period of years, I think their technology also became redundant very quick. So even
Hmm.
the inventor was not able to commercially exploit and monopolize their invention for the full lucrative term of 20 years, so to say. After
Yeah.
5 years, something better came up, and they lost their market. So
Right. Right. Right.
many inventions die organically,
Even with the protection. Even
even with
even
the
even with the
protection.
protection. Hmm. Hmm. Hmm.
There
Okay.
are many inventions which, so it is not a case, it's not a guarantee that your invention will get you the best results.
Right.
Today, I create a cure for a particular disease, which is a revolution. But someone improvises on that and makes it even better.
Hmm.
So all my hard work goes in vain because someone else used my work and improvised on it,
Hmm.
made some changes to make it better, and he got a better product which has a better market recall, better sales. So I'm not even able to commercially exploit or extract the benefits out of my hard work.
Hmm. Hmm.
So that limited duration of a monopoly, I think, is something that everyone deserves. And I think it's also very jurisdiction specific. For
Hmm.
instance, in US, you could patent almost everything. Like, I mean, if it's a new use of a known substance, you could patent it. In India, the patent law is slightly rigid. It's not as flexible. There are certain provisions which are considered as barbaric or considered as restrictive of innovation by a lot of the West. It is
Hmm.
not seen in a good light. Yeah, India has always been
Barbaric.
criticized.
Barbaric. How come?
Yeah, I mean, because there are certain Indian provisions which continue to serve the interest of the public at large. So if the patents were granted on those inventions, let's say there's a particular invention which is patentable in the US.
Right.
If that was made patentable in India, then the consumers here would be deprived of a level playing field, or they'll be deprived of the true benefits of that product, because here we have a massive population to cater, right?
No, so here's the example. Sorry, I know I'm interfering, but here's the thing. This is where lawmakers and regulators need to understand that on the one hand, they want to entice innovation, which will entail some monopolization and some legitimate rent seeking. But on the other hand, you want to disincentivize just pure rent seeking, because pure rent seeking, no new value is being given. So in the barbarity of India, where you can't get those patents, how is India doing? Is it doing better when it comes to innovation? or is it not doing better when it comes to innovation?
The genetics are not very favorable here. I would say
Okay, okay.
we have been in a chasing game,
Hmm.
um, and there's a lot of brain drain to blame as well. I think a lot
Oh,
of brilliant Indian minds, um,
yeah,
they don't stay here.
yeah, guilty.
Though so we continue to have that problem, and
Hmm,
I think it's more of the culture.
hmm.
uh, Innovation is driven by culture as well. There are
Okay.
certain organizations which are purely driven by innovation,
Hmm,
but if you see the Indian pharma, the Indian tech,
hmm,
where innovation should be at its peak,
hmm,
we are still doing a chasing game. We are still following the trend, and we
hmm.
try to get the best of what is done. And I
Yeah.
think the West is has always been, and it continues to be, ahead of the curve.
Hmm,
And we still have a lot to catch up
yeah.
when it comes to innovation. Though we do have the overall landscape. I
Hmm.
would say the overall IP landscape in India has improved a lot.
Okay.
Like in the past decade or so, I've seen a paradigm shift. There have
Okay.
been really remarkable developments and some great policies by the Indian government to encourage innovation.
Hmm,
But the problem with those policies is that the outreach is not good. I mean,
hmm,
we are trying our best to reach out to as many inventors, as many students, as many innovators as possible, but
hmm.
they are not even aware of how to fully use what the government has to offer
Yeah.
in terms of the incentives, benefits. There could be tax incentives,
Hmm,
rewards, reimbursements, etc.
hmm,
So right now we are really driven on propagating the best practices and the schemes, the IP schemes which are there,
hmm.
which have been floated by the Indian government in the year 2016, and they have been improved. And then there's a Ministry of Micro, Small, and Medium Enterprises, which in 2021 and 2022 have also come up with many new schemes uh, to promote innovation, to improve manufacturing capabilities in India.
Yeah.
So I think we are still in a phase where we are growing fast, and once this outreach is quite evident, I would say another decade or so, um, we are going to see a huge shift
Yeah.
in the overall approach of the Indian consumers, of the Indian business houses.
Hmm.
If the graph stays the way it has been for the
Yeah.
past few years, it
Yeah.
stays this way, I can see a very bright future.
Okay, great. I mean, the reason I'm interested in this topic is because I see it as an essential input to the spark, which we need to sort of keep lighting again and again, almost every day, uh, which leads to innovation. Because without innovation, without technology, you have a fixed pie, fixed economic wealth pie, and then more and more people fight, and more people. It just becomes very bad, right? So if you get stability, it's a very authoritarian kind of stability, very like top down structure. And if you do, so you don't get a lot of egalitarianism. And if you don't have that stability, or then you're getting violence because everybody's chasing prestige. So without innovation, that pie doesn't go, and without the right incentives, innovation doesn't happen. Unless, of course, somebody is just inclined to innovate or whatever. They're just blessed or whatever. So that's the reason why I'm really interested in this topic, and the right conditions in which that kind of innovation happens. You mentioned the culture of innovation. I just want to plug in sort of two thinkers I follow, Peter Thiel and Balaji Srinivasan, where we say, like, the terms developed and developing country. So developed, I don't like that term, and I agree with them. The reason is it's kind of saying that there is no more development needed. It's always developing. You need, so a better term is stagnant versus descending or ascending world, right? So, and of course, you always want to be ascending, because basically stagnant is eventual descension, and that's the reason why IP helps with this particular paradigm. But I still have to ask you, there might be people who abuse it, right? Who are using it in such a way where they'll basically create a slightly different version of a drug, and then not let the prices fall. and then just keep doing that, not really innovate, just do some minimum amount of work necessary to meet the metrics and keep gaming the system. That happens, right?
That is exactly what is discouraged under the Indian legal regime. So we
Acha.
call that as evergreening of patents. You can't
Oh, okay.
seek evergreening. So what you do is, a lot of big pharma companies have done that. So
Hmm,
they know that their patent is about to expire.
hmm.
Now they still want to commercialize upon that. So what they make is they make some cosmetic changes in the previous patent and file a new application so that they can get those rights as well.
Yeah.
The Indian patent regime discourages such patents
Right.
because the language, now the legal language, I'm constrained to use some legal terms here.
Sure.
So the Supreme Court of India, in a case against Novartis, it said that um, there must be therapeutic efficacy of the product. There must be enhanced therapeutic efficacy and not mere cosmetic changes.
Right.
So unless it is proven that there is some enhanced therapeutic efficacy, it will not be granted as a patent.
Hmm.
To again, I'd like to share examples. So I'll just share some very easy to understand examples. Let us say you take aspirin to relieve pain, and you stumble upon another use of aspirin, which is to in your blood. So it acts as an anticoagulant as well.
Okay.
Now, let us say this research was conducted in US and a US company found out that this particular product, which is aspirin, also helps in thinning your blood, which will reduce heart strokes. And this kind of new use of a
Hmm.
known substance
Hmm.
is registrable as a patent in US.
Oh, okay. That's a
So,
problem.
so,
Instead of
so the
off-license use.
American, so the US company can launch a new drug
Hmm.
by the same chemical composition and
Oh
label it
God.
as an anticoagulant and have a patent on it for 20 years. In
Man, that's
India, that is
cheating.
not permissible. I mean, so but that's not protectable in India.
Hmm.
Um, Likewise, when it comes to the enhanced therapeutic efficacy debate, so that's Section 3D of the Indian Patents Act, which was under consideration and which remains under a lot of scrutiny and attack by the West. So that basically means that the value addition must be tangible and must be in such a way that it really helps the patient. For instance, today, let's say I'm a patient having high blood pressure.
Hmm.
So I am required to take a medicine every morning after having breakfast. Now that medicine dissolves in my blood in 10 minutes, right? So there's a company which claims that they came up with a new medicine which dissolves in the blood in 6 minutes.
Okay.
This kind of patent is registrable in the US because they've come up with a better quality of medication, which
Okay.
is dissolvable in blood faster. So it
Okay.
acts on my body faster and I'm benefiting faster.
All
But
right.
the Indian patent system will say, like, maybe blood pressure is not a problem where, these 4 minutes can be really life threatening or it's really helping the patient. So in India, something like right now, I'm required to take a blood pressure medicine every morning.
Right.
What if a company comes up with a medication where I have to take only once a week?
Right.
That will be a revolution.
Okay, great. So here basically the system is saying that is this like a 10x improvement? Is it like a 100x improvement? Or is it like a 0.1, 0.002x improvement? But I'm just concerned about the second example here, Gaurav, because you said that the second company in which the system starts acting in 6 minutes, did they create the chemical composition on their own, or did they use something else which was about to go generic? What was the situation?
So it could be both. It could be either ways. But ultimately, the end result is that the salt is dissolving in your blood faster than it was before.
Okay.
And
The only thing I will just, my uninformed opinion is that if they're doing it with which is something already known and just tweaking it a bit, then that obviously that is something which is a problem, and regulators need to get smart to that. But if somebody just created something from 0 to 1, and it's just that, hey, it does it in 6 minutes, personally speaking, let it out, right? It's anyways going to lose in the market. If it's any, because it's going to be the same price. They can't price it more than the competitor which is already out there, right? Market forces are real anyway.
Yeah.
So that isn't okay. If I want to start a startup, and if I want to write to investors, like at the idea stage, seed investors, do you think the business plan and the proposal, I should go and copyright it? Is that something? How do I protect my idea from becoming a company by someone else?
So ideas per se again are not protectable.
Okay.
When those ideas they take the form of a creation,
Okay.
they are protectable.
So
Now,
if the proposal will be protected, but somebody could make a business. Is that what you're saying?
what I'm saying is if there's a business model that you have.
Yeah.
So in US in particular, the laws are more IP friendly and more robust because you have a trade secret law.
Okay.
Wherein you can also, so trade secrets are not recognized in India, not yet. So we are about to have a legislation soon. Maybe by the end of next year, we'll have another legislation to protect
Okay.
trade secrets. As on date, trade secrets are not protectable in India. But in US, if you have a model, an idea, which is privy to you, you write it on a piece of paper and you share it with someone, which is extremely confidential. So you will be protected under the laws of trade secrets in the US. I'll give you some examples of products which are registrable as trade secrets and which continue to remain so in the US.
Okay.
The composition of Coca-Cola. Coca-Cola, the chemical formulation, nobody knows it.
Right.
There are thousands of colas there in the market.
Yeah.
But they all taste different from real Coke.
Yeah.
The original Coca-Cola. You can simply taste and tell this is not Coca-Cola.
Yeah.
Because their novelty, their invention remains a trade secret.
Yeah.
Likewise, there's a KFC recipe of frying chicken. It's a trade secret. Then you have WD-40. Are you aware of the product WD-40?
No.
It's an anti-corrosion and anti-rust spray. It's an American company. It's one of the biggest American companies, and
Okay.
it's world's largest anti-corrosion and anti-rust spray. So WD-40 is water displacement in 40th attempt. So the scientists stumbled upon the best way to displace water in
Right.
40th attempt. That is how the company was formed, WD-40. And that method remains a trade secret. There have been several attempts to reverse engineer and come back to the main composition of the product and have the same products. And there are various copycats in the market, but there is no other product like WD-40. So it depends on you. If you want to keep something as trade secret, you very well can.
So
But
is
let me
this
say,
infinite? Does it have an expiry, the trade secret,
no,
or is this for that is, I would argue that is
it's
stopping innovation. After a while, it is stopping innovation. I want to build
so,
on that, not just try and keep copying it, rebuild the wall, whatever the wheel.
so there is no stopping in. See, when you are launching a product in the market, you've already
Yeah.
disclosed what it contains. So everybody knows what the product is, and trade secret, if someone is copying the product, like as in the chemical composition, and they're launching in their own brand, I can't sue them.
Yeah.
I can sue for trade secret violation only and only if the person with whom I'm having such an agreement violates it.
Right.
Not otherwise. So there is no, this is not stopping innovation. Trade secrets I think are a perfect safeguard for someone who does not want to disclose how the product was made or what is the process involved, because the moment I disclose the process, that is when I'm entitled to claim the patent.
Right.
So trade secret is an alternative to patent. I don't want to disclose all my steps, what are the novelties, what are the inventive steps involved. I'm simply interested in securing my know-how. I can do so under the trade secret law. But your business model, for instance, you have a great idea and you launch an application. So the moment you have that application, there is an algorithm which went on to create that. So you can file that algorithm, that software as a copyright.
Okay.
But let's say someone is inspired. So again, inspiration and imitation, we have to be very careful here. So someone is inspired by a business model and they create their own. Use a different business algorithm. And the layout of their website, their application is different, but the concept is the same.
Yeah.
You can't stop that. They use a different algorithm. They use a different business model to create that. Have a different layout. You have a logo in blue and red. They have a logo in yellow and green. I mean, then there's no violation as such.
Right. Right.
That will be considered as anti-competitive.
Yeah. Yeah.
And then competition law and IP law, again, there is the dichotomy there as well.
Yeah. Competition law and IP law.
Yeah. So whether IP is anti-competitive.
But yeah. Whether IP is enabling rent seeking or whether IP is enabling innovation, what's the right amount of monopoly? Those are the questions that the IP law is, I think, trying to ask. And the problems it's trying to solve is how do you get the right amount of not the right amount of innovation? How do you get the most amount of innovation without sliding into what's the point? I wouldn't be rewarded anyway. Like no IP, or hey, what's the point? These guys have everything and they're not going to innovate. So what's the right sort of middle path?
I think we already have sufficient and very adequate legislative framework to both incentivize the right IP and also to disincentivize the abuse of dominant position in a market. If there are some certain dominant undertakings in the market, so the Competition Act ensures that those dominant undertakings are not abusing their positions.
Right.
And people like Mark Zuckerberg have been summoned several times and they've been held accountable on their practices.
Yeah.
On privacy laws and other laws. So they cannot simply because they're too big to fail or too big to be accountable for, they can't be just can't just let them go.
Yeah.
So there are laws to check. I think there's a nice balance of both IP as well as competition law to ensure that IP is not allowed to be monopolized, or it's not allowed to be misused in a way that it stifles competition.
Yeah. So that's okay. Last segment, so I'm gonna have to go fast with the questions. How internationally, let's just say, synergized is IP law? Because most companies, I mean, I guess the aim is a TNC or an MNC. So how synergized internationally is it? And when I say this, I guess I also want you to explain how it works differently within common law systems and civil law systems, or if there is a difference anyway.
I think IP law is one of the most globally connected and synchronized legal practices anyway.
Okay.
IP and arbitration are two such laws which are very synchronized and harmonized globally. But despite of that, the countries have been given a liberty adopt those frameworks as per their own environment and their own holistic framework.
Okay.
So there is an international body which regulates all of this, which is the World Intellectual Property Organization, WIPO, and there is an agreement called the TRIPS Agreement, which is Trade-Related Intellectual Property Rights Agreement. So India is signatory to the World Trade Organization and is substantially TRIPS compliant, and likewise most countries these days are members of TRIPS. So the moment you are members of TRIPS, you have to follow a certain guideline and legislate your own IP laws in harmony with the global IP framework. So a lot of things, for example, the procedures in principle are overlapping in India and Europe and US and most of the Southeast Asian countries, because if I have to secure my let's say, a trademark registration,
Hmm.
the procedures would more or less be the same. The timelines will be different,
Okay.
but
Okay.
the mannerism and the way those rights are granted are pretty much the same. In most countries, patent rights are granted for 20 years, but there are some countries which may have a couple of years here and there.
Yeah, I mean, I guess harmonization is very important, especially because if you want to avoid the cost of going international. So for example, the golden M for McDonald's, I'm assuming they need to keep renewing it again and again. Do they need to do this in every country, or if they've gotten it registered in the US, every other country agrees with it because it's in the US? So yes, like they recognize marriages, right? I don't have to remarry if I move with my spouse in some other country, right? So what happens there? So is there cross jurisdictional recognition?
So, in as much as the rights are harmonized, they are
Hmm.
very much territorial in nature.
Okay.
So,
Okay.
unfortunately, McDonald's will. So, if you talk about, let's say, McDonald's is a good example. It
Right.
will have a trademark portfolio of maybe 5,000 trademarks which are registered all over the world. Maybe 50 in US, maybe 100 in India, maybe 200 in China. I don't know. Just to have some numbers, they will have a huge trademark portfolio and a huge team to manage to ensure that all these trademarks are timely filed, renewed, registered. So likewise for patents, patents are also very territorial specific, very jurisdictional. So
Right.
a patent registered in US is not enforceable in India, but there are some countries which give certain degree of recognition, and a lot of common law countries, they
Right.
recognize that if it's a big brand which is
Yeah.
registered, let's say in US, and
Yeah.
let's say it is not registered in India, it
Yeah.
will still have some value.
Right.
How? So let's say today I have a lot of international exposure, and I went to the UK for my studies. In 2011, I got back home. I saw in the UK that there is a famous chain of restaurants by the name of ABC
Right.
XYZ.
Right.
And I know that there is no other chain of restaurants in India by the same
Huh.
name.
Yeah.
I I opened up exact same chain of restaurants in India,
Hmm.
but ABC XYZ, and
Yeah.
having the same logo, same color combination, and people in India who have exposure to overseas, they come and
Hmm.
see, oh, like this now this is in India. They
Yeah.
don't know
Yeah.
that it's not them, it's me.
Yeah. Yeah. Yeah.
So the Indian law will prevent
Hmm.
the UK company
Okay.
from such bad faith registrations and use which I have done.
Okay.
So if
Okay. But
so if the UK company comes to India and says,
hmm.
"Hey, India was not in my consideration, but when I want to invest here, I see that my brand is already misappropriated by someone else.
Hmm.
They have filed the trademark applications, obtained registrations, they've started their restaurants, but it's my brand, and that company from UK will have to file a lot of documentary evidence to prove that my registration and use in India were done in bad faith."
Okay.
So, so once that is proved, then the court will issue us an injunction against me. There'll be a stay order. I'll not be
Okay.
able to use that mark again. I'll perhaps have to pay some amount in costs and damages. So all those components are there, but not every country has that. For example, in China,
Yeah.
China does not follow that. In China,
Right.
if you file, you are the king. So
Yeah.
China follows first to file principle. It does not look
Okay.
into the first to use. It's a
Okay.
different world altogether in China. So
And
it depends on jurisdiction to jurisdiction.
it also doesn't take cognizance of happenings outside its jurisdiction. It's a weird kind of legal. Yeah, law is a legal kind of weird kind of fiction. Like it's just like, okay, so if this happens here, as if the other world doesn't exist, as if no air is going to travel from there, whatever. But okay, so this is interesting. This has been really interesting, man. Okay, I don't think, I mean, I have a lot of questions, but then I can just keep going. So we can conclude here. Do you have any parting thoughts? If you just want to put your thoughts together, just before we go.
I just have a small message to convey to everyone, to all the youth in particular. I think we should not be lured by the brands the way we are,
Hmm.
because it is time that we understand respecting someone else's IP is extremely important. I mean, of course, if you can afford something, go for it, but just don't buy a replica because you can't have the real one. There are thousands of alternatives and very good ones these days. I mean, you can have exceptionally good quality alternatives to serve your interests. By not buying counterfeits, I think that's saying no to counterfeits is a big message to the trade that we are not impacted by your productions, and we'll continue to follow the best practices. Don't download pirated softwares. Don't download pirated music. It's time we become IP savvy, because that is how the future is. If the more developed we are, the more educated we are, I think it's not only our legal responsibility, but also moral responsibility to ensure that we make sustained efforts to respect and create IP.
Yeah.
So that's my short note to conclude.
Perfect. All right. Well, thank you very much for your time, Gaurav, and thank you everybody for listening. See you in the next episode. Bye-bye.